Thank you. I was just thinking, I wish I had thought to bring it.
Thank you.
I may have to plunder an entire extra table here. I'm sure they can arrange, but yeah, that table.
That's the table. Yep.
And if anyone comes in late, they can always have it. You got it.
Thank you.
Oh, thanks. That's suburban
coffee.
coffee.
Thank you.
Thank you very much. One thing you'll find is
Yeah.
already there.
I decided to go have bad vision and go bald at a very young age. Give myself. I associate these with you.
My son is 40 and he's bald. Could be a good thing.
GW, yeah. 16 years.
Are you actively involved? PC is a great place to be able to, on a daily basis, mix all these organizations.
Definitely. I've been moving to LA, so that's part of the factors I had to consider. Yeah.
Who's the dean there now?
Andrew Guzman.
Guzman, yes. Yeah.
Do you want me to just start? Oh, I thought somebody was going to take it off. Gee, I thought that's what I was supposed to do. Sorry.
Try not to get it here.
We're going to go ahead and get started if you guys are about ready. My name's Jan Crawford, and I'm a correspondent with CBS News. I cover the Supreme Court, and it is my great honor to be here to quote-unquote moderate this event, which we were saying earlier, I have the easiest job you can imagine. I'm going to introduce these incredible legal experts, and they're going to discuss what is shaping up to be a pretty remarkable term. I was thinking, you know, I started covering the court in 1994, so I've gone to a lot of these Supreme Court preview sessions. As I know a lot of my colleagues, we can kind of empathize about this. There will be years where you sit in the crowd and there will be a fine panel of experts assembled, and there literally are 3 cases that you really care about. So you'll have to like kind of wait for each person to finish their remarks till you get to the one case that you're really interested in. That is not the case this year. All of the cases that we're going to be talking about today are extremely important, different, and I mean, again, shaping up to be, I think, what is a landmark term, but maybe with not at least one of the cases that we thought we were going to get. I'm going to start by introducing our panelists. They are going to talk for 5 or 6 minutes each about some of the cases that they are very well versed in, and then kind of react to each other. And we may have some discussion at the end, and then we'll open up to questions. So you guys feel free to, I'm sure there's nothing that they can't answer. But first of all, we're going to kind of start with Professor Samuel Estreicher. You guys, of course, all know he is a professor at NYU School of Law. He's director of the school's Center for Labor and Employment, co-director of the Institute of Judicial Administration. He has taught, lectured widely on matters of federal jurisdiction, foreign relations law, United States, arbitration, complex litigation in U.S. courts, and actively involved in amicus capacity in a number of cases involving the kind of the place of international law in U.S. domestic law and the Alien Tort Statute, including his recent brief on behalf of U.S. foreign relations law experts in Jesner versus Arab National Bank. And in 2016, he was appointed by the UN Secretary General to serve as a member of the UN's Internal Justice Council. He's a graduate of Columbia Law School and clerked for Justice Powell. He will be talking about Jesner versus Arab Bank and the travel ban cases, which he says I should refer to as travel pause. Andy Pincus is going to be up next. He is a partner of Mayor Brown, and I think distinguished Supreme Court advocate is really the best way to describe him. He's argued 27 cases in the Supreme Court, and he's won quite a few of them. Law 360 ranked Andy's victory in AT&T Mobility versus Concepcion as the most important Supreme Court class action decision of the last 15 years. And in 2016, they named him an appellate MVP. He was recognized in 2015 as a litigation trailblazer. His Supreme Court work, his defense of Mayor Rahm Emanuel's run for mayor, right to run for office, cited by American Lawyer in its article naming Mayor Brown one of the top 6 litigation firms in 2012. I could go on and on about Andy and all of these fine panelists. He's worked in the SG's office. He co-founded Yale Law School's Supreme Court Advocacy Clinic. He has served as general counsel of the Commerce Department. Graduate of Yale and Columbia Law School. He's going to talk about Epic Systems, the significant arbitration case, among others, and has some thoughts on several of the other cases our panelists will be discussing. Orin Kerr is a nationally recognized scholar of criminal procedure and computer crime law, director of the Cybersecurity Initiative at GW Law School. He's been a tremendous resource, certainly to not only the courts and litigants, but also viewers of television networks and in the Washington Post because of the work he does in explaining and teaching some of the things that the courts do, and he will be leaving Washington, sadly for us, but happily for him to go teach at USC Law School in January. He's a former trial lawyer in the Justice Department's Computer Crime and Intellectual Property section. He was a special assistant U.S. attorney in the Eastern District of Virginia, argued many cases in the Supreme Court and the federal appeals courts, testified 6 times before congressional committees, which will be harder to do from out there in LA, Orin. Maybe you want to stay.
That's okay.
But, you know, he's authored, co-authored case books, has authored the leading criminal procedure treatise, and like I said, he posts regularly, making some of these complex areas of law accessible to viewers, particularly on the Volokh Conspiracy Legal blog. He's a graduate of Harvard, and he clerked for Justice Kennedy. Sitting next to me is Kyle Duncan, who has argued more than, you guys getting the theme here? He's argued more than 30 cases, a panel of heavyweights in the federal and state appellate courts, numerous cases for parties and amici in the U.S. Supreme Court, and argued 2 cases in the Supreme Court. From 2012 to 2014, he was the general counsel of the Becket Fund for Religious Liberty, and this will not surprise you, among other cases. He was lead counsel in Hobby Lobby. From 2008 to 2012, he was Louisiana's first Solicitor General. You're a native of Louisiana, I do believe. Is that right? Representing, obviously, the state and public officials before the Supreme Court, the Fifth Circuit, Louisiana Supreme Court, and so on. He received his JD from LSU, LLM from Columbia, and clerked on the Fifth Circuit. And I was going to commiserate with you about your school and your state, you know, and say roll tide, but after what transpired in my great state last night, I don't really think I can say much of anything. So maybe Louisiana doesn't look so bad after all.
Did Nick Saban quit?
Fortunately for Alabama, we still have Nick Saban. Everything else is going down there. I really want to. Let's move on. And finally, Carrie Severino, Chief Counsel, Policy Director of the Judicial Crisis Network. She's testified before Congress on assorted constitutional issues, briefed senators on judicial nominations, obviously recently taking really the lead in supporting the Gorsuch nomination. She's been extensively quoted in the media, again, kind of bridging that, you know, kind of taking these complex issues of the law and then presenting them to the people through the media. She's appeared often on television, including CBS News. And she's just written and spoken on a lot of judicial issues, particularly constitutional limits on government, the nominations process. Until 2010, she was a fellow and dean's visiting scholar at Georgetown University Law School. She's a graduate of Harvard Law School, and she clerked for Justice Thomas. And I might add, on the way over here, she stopped by the Museum of African American History and Culture to see its new exhibit, which does now have a mention of Justice Thomas. So you may want to ask her about that. You thought it looked...
It took about a year, but they finally remembered that he's one of the most significant and admired African American figures in American politics, certainly today. So.
Yeah, well, and you said it was pretty well done. It's with Thurgood
Marshall.
Yeah,
it was. You know, it's a small corner on him and Justice Marshall, who they had also left out. So I think they kind of had a serious blind spot.
Equal opportunity
for the court, but it is now, you know, I suppose better late than never. I'm glad to see that the oversight has been remedied. I think there's still a little bit of a heavier focus on some of the less significant issues than they need, but it's good to have them there.
All right, so as you can see, this is like the best possible group to talk about this, what's looking like a really interesting term after a real snoozer last year. So I thought, let's start with you, Professor Estreicher. We're going to talk about Jester versus Arab Bank and the travel pause cases.
On Jester involves the Alien Tort Statute, which was enacted in 1789. And until the Second Circuit's decision in Phil Artiga, this statute was cited only twice in all U.S. courts. And Henry Friendly called it the Lohengrin of U.S. law. And the statute is very broadly worded. It was a section of the Judiciary Act of 1789. It simply says that it's federal jurisdiction over actions involving torts committed in violation of the law of nations or of treaties. There's been virtually no litigation on the treaty clause. But under the law of nations, since the Phil-Ortega decision, there has been. The Supreme Court had its first crack at this case in a case called Sosa, at the statute, a case called Sosa versus Alvarez-Macon, where the U.S. government argued that the Alien Tort Statute is only jurisdictional. The court rejected that argument. It said that there is a cause of action there. Actually, the Sosa decision is almost entirely dicta, but dicta is data when we deal with the Supreme Court. I call it dicta because the Supreme Court actually rejected the plaintiff's claim in that case, but Justice Souter wrote a very elaborate opinion on the notion that modern international law violations can be reached by this statute. These actions have to involve international norms that are universally accepted as binding rules and that are sufficiently clearly and definitely stated so they could be the basis of a federal cause of action. The decision had lots of possible exceptions and open issues, such as whether the exhaustion would be required, and one of the open issues was who are the parties that can be sued under the Alien Tort Statute. In the Second Circuit took the position early on that corporations cannot be sued under the Alien Tort Statute because there is no clear, universally accepted, definite rule saying that corporations are liable for violations of customary international law. And that is true to this day. Even in situations like Nuremberg and with respect to the creation of the International Criminal Court, corporations were not included as defendants. There isn't, in fact, an international consensus on when corporations can be sued for violations of criminal law or international law as a matter of the customary law of nations. That was the position the Second Circuit took. This caused a great deal of alarm in plaintiff circles because the only defendants that are sued under the Alien Tort Statutes are corporations. And they're sued on a variety of different theories of accessorial liability, aiding and abetting liability. So a case from the Second Circuit called Kiobel versus Royal Dutch went to the Supreme Court. In Kiobel 1, the case was granted by the Supreme Court. The certiorari petition was granted on the theory we're going to decide corporate liability. There wasn't full briefing and an argument. And then the justices decided we're going to set this case for re-argument. And so there was Kiobel 2. Kiobel 2 was ultimately decided by the court. It went against the plaintiffs. The theory that the court advanced was the statute has to be read against, the Alien Tort Statute has to be read against the presumption against extraterritorial application. And given the fact that nothing in that case involved the United States or any U.S. events or any U.S. parties, the court said that the complaint had to be dismissed on the grounds that it was impermissibly extraterritorial. The court left open some language which is going to require litigation. The claim has to touch and concern U.S. interests, is what the court said. And there was an elaborate concurrence by Justice Breyer on the notion that what his view of touch and concern was. So that was Kiobel 2. The Second Circuit had a third case now involving Gessner versus Arab Bank. This is a case, again, where all of the events occur essentially outside of the United States. It involves the biggest bank in the Middle East. It's headquartered in Jordan, and the claim is that the bank has facilitated payments to terrorist organizations. The bank denies this. The United States has certified that the bank's procedures are up to snuff with respect to the anti-terrorist measures that the Treasury Department and the State Department have mandated. The only connection with the United States is that this bank, on some transactions where the parties want dollar-denominated currencies, they have a correspondent bank, small correspondent bank in Manhattan, and that's the only connection with the United States. The case is now it was in the Second Circuit, and the Second Circuit said corporations are not liable. That's our position. that we announced in Kiobel 1, and Rosemary Pooler wrote an opinion for the Second Circuit that, as much as she could, criticized Kiobel 1, but said that's the law of the circuit, and the case has been, was granted by the Supreme Court. So the issue of corporate liability is back to the Supreme Court. There is a problem with the case because all of the events occurred outside the United States. It's a problematic case under Kiobel 2. That should have been the ground that was adopted by the Second Circuit. It's not the basis of the petition that's filed, although it is strongly urged by the respondents, by the defendants, that the case should be dismissed under Kiobel 2. The United States government, interestingly, filed an amicus brief in support of neither side, where they essentially said in the brief that there should be corporate liability under the Alien Tort Statute because there's no express exception for corporations, and because there were analogs to corporate liability in the United States view with respect to admiralty lawsuits against pirate ships that engage in piratical activity. That is sufficient evidence of congressional intention in 1789. The U.S. government said there is corporate liability, but there's a very serious question about extraterritorial application, and we urge the court not to decide it here, but to send it back to the Second Circuit, even though there are no factual issues about the extraterritorial application question. So, my prediction, ordinarily I do not make short-term predictions. I can tell you what's going to happen in 30 years, and we'll stand by it.
But wait, does that mean, so we'll be okay?
You'll be okay. I think it is likely that the court is going to decide the case on the Kiobel 2 grounds of the extraterritorial application. On the other hand, so I'm not going to give you a 50-50 kind of thing, that is the strong basis for deciding it. We urge in our brief another basis, and that is the Alien Tort Statute does not apply where no duty of the United States is alleged to have been breached to a foreign nation. And indeed, the whole theory of the plaintiffs in their complaint is that the Arab National Bank is breaching U.S. regulations, not that the U.S. is doing anything wrong. We think that was the purpose behind 1789 statute, and that should be a ground. Now, the court seems to want to decide corporate liability because, I was there for the argument in Kiobel 1, and there was a degree of discomfort. On the other hand, this is, in fact, the big issue under the Alien Tort Statute. So my prediction is, notwithstanding the U.S. government's recommendation, in all likelihood, even though the court might want to decide corporate liability, this is a lousy vehicle for deciding it because of the very strong extraterritorial application problem with the case. Should I go on to the other case?
Travel pause.
Travel pause. Now, this is a case that's very much a moving target because, as you know, there were deadlines, expiration dates set in the initial executive orders by the Trump administration, and now the Trump administration has come out with a new, it's called a proclamation, by the way, not an executive order, but to my reading, it seems to solve a lot of the problems that the lower courts had. Not all the problems, but a lot of the problems that the lower courts had with the previous executive orders. There's no question the first executive order was a very slapdash job. When I teach an NYU class, I say it must have been an uptown job. Even though I went to Columbia Law School, I try to generate some NYU patriotism. But a very, very sloppy job in every respect. This new proclamation exhibits a great deal of interagency review. It seems to do a very good job. It makes the findings that some of the lower courts insisted were missing, and it changes the number of countries that are involved. So I just did a little checklist on this. Chad has been added as a nation that has inadequate procedures for information sharing and identity verification. Venezuela has been added. I don't know if we have a lot of visitors from Venezuela. I suspect we will, given the turmoil in Venezuela. Venezuela has been added to the list. And not surprisingly, North Korea has been added to the list. All the other countries were on the previous list. Two countries that are off the list are Yemen and Sudan. I don't know why entirely. I think there was a lot of uproar about having Yemen on the list. This order purports to be based on this interagency review of the procedures of over 200 countries, their procedures for information sharing and for verification of identity problems. It's what the Trump administration should have done initially before they let out the order. So I think, you know, it strikes me as a reasonable attempt to deal with the problem. A whole bunch of exceptions to it. So happily, permanent resident aliens are excluded from the travel pause, and if you're here for diplomatic reasons, you're excluded. These were exclusions that were not present in the first executive order. So I think a lot of the problems have been solved. Not all of them, because we know there is the theme of the lower court opinions and the briefing was that the president, the president is impeached, not being able to use, I shouldn't use the word impeached, barred. The president is barred from exercising his plain statutory authority under the immigration laws to deal with this, with visa issues, because he said incautious things on the campaign, or at least statements that are capable of being viewed, reasonably viewed, as exhibiting a bias against Muslims. Maybe that's why we have some non-Muslim countries on the list here. That's something that's being said in the media. It's a very odd notion that you can be impeached for your campaign statements, even though, in this case, we're engaging in interagency review. And does that mean that the president, there are real practical problems. Is the president barred for both terms from making immigration decisions? Does the president's comments also bar the people he's consulted, like the Attorney General, the Secretary of State, Secretary of the Department of Domestic Security? What's the name of that agency again? DHS, the Department of Homeland Security. I resist the word Homeland. The Department of Homeland Security. It just can't be the case that we have this sort of rule. And of course, the Supreme Court precedent in this area is Kleindienst versus Mandel, where the court said you essentially have to take the government's word. If the document, if the agency action, if the presidential action is objectively neutral on its face, you've got to take the government's word. You can't impeach for motive. Now,
but Professor, yeah. let me ask this, just kind of the bottom line.
I mean, it seems Sam, by the way.
Sam, okay. It seems that the court has taken this case off the calendar while it considers whether or not it's moot. It seems to me that you're suggesting the bottom line is that whatever is going to happen, that case is going to come off the calendar, probably will be moot, and we'll then have new litigation over this new travel pause that sounds to me like you're saying should withstand muster, unless...
In the long run, it will. It may take... We're going to have this litigation. I think Andy and I have predicted it's going to bedevil the Trump administration, in part because we're all under a kind of Trump disease, whatever our politics. But this is actually bad for the sound administration of laws to have this kind of impeachment for bad motive when you're dealing with governmental action. So we're going to have the litigation. But I think the Ninth and Fourth Circuits will be a little more, they'll be deterred. It'll be harder for them to do it with respect to this order. But, you know, I guess under the rules of the circuits, once they file the complaint, there'll be filings before the same panel. It'll be so we may end up with the same panel decisions. I'm hoping to see more of a girding of the loins and some courage from the other members of those circuits. It's a very serious problem. This happened during the Obama administration, and maybe our voices should have been louder to have a single district judge issue a ruling for the entire nation. It's inconsistent with what the Supreme Court has held about offensive non-mutual estoppel not being available against the government, letting the government relitigate issues because that's necessary for sound administration of the laws. It's a problem. So I'm hoping that the Fourth and Ninth Circuits see some problem with continuing the path, but I don't think I think they will find some way to come back and may have to shed some aspects of their rulings. So we did some research this morning on a case called Munsingware. When a case is dismissed as moot, there's no automatic vacator of the ruling, but the court on motion or on its own suggestion will vacate the ruling. So the government, I think, will be happy with that outcome, vacating of the ruling, and it'll be a signal, hopefully, to the circuits.
All right. I know, Andy, you wanted to kind of weigh in on this. Thanks very much, Sam. If you want to weigh in on this, and then just kind of, we're going to also, anyone else on the panel want to react, and then we'll take it from there.
Sure. I think there certainly will be more litigation. And I think, you know, Sam is probably right that the motive arguments are going to become more attenuated as time goes on. But to me, the interesting arguments are the statutory authority arguments, which was the basis of the Ninth Circuit's decision. The President relies on this provision of law 1182F, which seems to give very, very, very broad authority to a president to bar the admission of almost anyone for any general reason. And one question that the Ninth Circuit grappled with is, could that really be so open-ended? Wouldn't there be a delegation problem if the authority was really open-ended? Is there some judicial review? If so, what are the limits? And some people have said, for example, that one of the limits, if you look back at how this authority has been used in the past, was time limited. This is the first time that the authority will be used to permanently, at least with no time limitation, impose restrictions that are different from those that were enacted by Congress. And if that authority is upheld, you really wonder about the stability of our immigration system, because a president presumably could just say, I'm going to rewrite the immigration laws using this authority and override all of the rules that Congress set up for various categories of immigration and visas, and that seems like that would be a very strange result. So my guess is there'll be a lot more focus on both the duration and whether there's some justification for overriding the otherwise existing rules that Congress put in place, for example, to screen out terrorists.
For the bottom line, I mean, we're not going to be getting arguments in travel ban this year.
No, I don't think. I think the Supreme Court is going to say the order that we granted review to consider is gone,
is moved,
and this is going to be sent back, and there'll be lots more litigation. Good for lawyers.
All right, Will, do you want to talk about a case that we actually are going to hear arguments on?
Yes, yes, I will do that. I have to make one comment about Jesner and the Alien Tort Statute, just because this group will appreciate it in particular. In the Sosa case that Sam referred to, Justice Scalia filed a separate opinion, basically saying, although the majority says they're just opening the door a crack to claims under the Alien Tort Statute, that won't be so, and this will be the font of lots of litigation. And he was incredibly prescient, because since that day, there has been a whole little industry of alien tort litigation that that bottle has not, the genie hasn't been close to been put back into the bottle.
All against corporations, by the way.
Yes. Well, that's where the money is. So thanks, first of all, to the Federalist Society for inviting me. This is always a great event. I'm going to talk about the arbitration cases called Epic Systems. There are 3 cases that were granted and consolidated: Epic Systems, Murphy Oil, and Ernst & Young. They are the first argument in the term on the first Monday in October at 10 o'clock, and probably the most consequential arbitration issue to come before the court in the last 4 years, even though there have been a number of arbitration issues. And just to make a disclosure, in this case, and probably a bunch of the other cases that we're going to talk about, I filed briefs for various parties. The question in this case, put simply, is it an unfair labor practice to include a class action waiver in an agreement to arbitrate that is part of an employment contract? Since employment arbitration agreements routinely include class action waivers, this case affects the validity literally of tens of millions of arbitration agreements around the country. People sometimes hear the NLRB or the National Labor Relations Act and they think, well, that only really has to do with unions. Not so. Its authority extends to all employers of over a very small number of employees. So this is an issue with very broad ramifications. The Supreme Court held in 2011 in the Concepcion case that the Federal Arbitration Act preempts state laws that would invalidate arbitration agreements with class waivers because the FAA preserves the idea of individualized arbitration, one-to-one dispute resolution as a core aspect of arbitration. So the NLRB just the very next year, in 2002, ruled that it is an unfair labor practice to include a class waiver in an employment arbitration agreement, relying on Section 7 of the National Labor Relations Act, which, just to give you some statutory language, protects the right to self-organization, to form, join, or assist labor organizations, to bargain collectively, and this is the key language, to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. The NLRB said that catch-all clause includes the right to participate in class actions. Class action waivers prohibit class actions, and therefore they constitute a violation of Section 7, and violations of Section 7 are unfair labor practices, therefore they can't possibly be enforced. And the board said the FAA does not bar the application of the NLRA to invalidate all of these agreements. But there is a long line of Supreme Court cases that hold that the Federal Arbitration Act does not just preempt state laws, it also applies to federal laws in a similar way. It limits the applicability of federal laws that would invalidate an arbitration agreement unless there is an expression of congressional intent to the contrary in the text of the other federal statute. In other words, the FAA sets up a general presumption that federal law is favorable to arbitration, and a general presumption that arbitration agreements will be enforced according to their terms, unless there's something in some federal statute that indicates Congress meant to override that general rule. The problem here is that Section 7, the language I just read, doesn't say anything about arbitration or litigation. It does talk about collective action, but all in the bargaining context, labor organizations, things like that. It's awfully hard to see in those words a congressional decision and that's basically the argument of the proponents of the arbitration agreement. They say Section 7 doesn't contain the necessary congressional intent, and the NLRB can't fill that in by interpreting ambiguous language. Maybe it can say that outside of the arbitration context where the FAA applies, there's some protection for class actions, but it can't supply the requisite congressional intent to override the FAA. Now, the other side says this is a substantive right conferred by the NLRA. Substance is important. All of those Supreme Court decisions that I mentioned talk about procedure. For my money, any argument that turns on the difference between substance and procedure really is labeling and not substance. And so it's hard to say why something is procedural if there's a statute that says you have a right to go to court in the context of creating some cause of action. Why is that procedural, but this is substantive? Very hard for me to see the distinction. And of course, the Supreme Court has said repeatedly that Rule 23 is a procedural provision. The opponents also rely on the FAA's savings clause. The very end of the critical section of the FAA, Section 2, says arbitration agreements are enforceable, and the magic language is save upon grounds as exist at law or in equity for the revocation of any contract. So they say, well, the NLRA makes this contract illegal. Therefore, all that's happening here is we're applying the general rule that illegal contracts are unenforceable. The problem there is that if that were true, all a state would have to do would be to pass a law saying all arbitration contracts are illegal, and then say, oh, we're not singling out arbitration, we're just applying the general rule that illegal contracts can't be enforced. So that proves too much, I think. A little bit of background on the case. This is not a one-off Obama administration anti-arbitration rule. There was a whole raft, post-Concepcion in particular, of anti-arbitration regulations issued by just about every alphabet soup agency you can think of, HHS, Department of Education, the Department of Labor, the Consumer Financial Protection Bureau. Many of those have been enjoined or reversed. This one hasn't been, although it'll be interesting to see if the NLRB continues to stand behind its decision. On Monday, the fifth member of the NLRB was confirmed, and so now there is a full complement of NLRB members, and so who knows what the current NLRB's view is of this rule. Certainly some of the existing members dissented from the application of this rule in some cases that they decided. The other interesting thing to note about this case is the Justice Department, although in the Obama administration it filed a cert petition on behalf of the NLRB after the change of administration, the department authorized the NLRB to continue to litigate the case, but filed an amicus brief on the other side of the case saying that its view was that the NLRB's position is wrong. Not at all an unprecedented thing to happen in a change of administrations. It happened a number of times in the Carter administration, but certainly has given the case some extra profile. I want to, if I can, talk briefly about one other case, a case called Oil States. Normally when I mention patent law in a general audience like this, people say, oh my God, you know, is he going to put up some formula or diagram? And my rule about litigating patent cases is don't ever handle a case that has a formula or a diagram because that's too scary. Stick to the law. But Oil States arises in the patent context, but it's a quite important separation of powers case. And I think, as we'll talk about later, this term, one of the themes, may well end up being a very significant series of rulings on separation of powers issues, depending on what happens with some cases that are in the pipeline. So as everyone knows, patents are granted by the Patent and Trademark Office. Recognizing that errors can occur, particularly because the granting of patents is not an adversarial process. Patent examiners may not uncover all of the relevant information. Congress created a procedure for third parties to petition the PTO for correction of erroneously issued patents. That procedure sort of was first created, the first version was created in the 1980s. It's been revised a couple of times, most recently in 2011. And those decisions of the PTO, of course, are reviewable in the Federal Circuit. That process is being challenged on two constitutional grounds. First of all, as a violation of Article 3, that it's an intrusion on the judicial power to allow adjudication of these questions by an Article 1 tribunal, because these are private property rights. Justice Thomas wrote a dissent in a case called B&B Hardware in the trademark context, in which he adverted to this being a potential problem. He didn't come down one way or the other, but flagged it as a question in the trademark context, not in this patent context. And the second constitutional allegation is that this is a violation of the Seventh Amendment, that the patent owner has a right to a jury determination of the issues relevant to the validity of the patent. The argument on one side is this is a property right, and property rights should be protected by these two constitutional provisions. The argument on the other side basically has been this is a right created by the government. It doesn't exist apart from the grant by the Patent and Trademark Office, and therefore the PTO reconsidering its own decision doesn't breach any constitutional constraint. Interestingly, there's some Seventh Amendment history in England of the courts of chancery invalidating patents challenged by third parties. So history is always critical in the Seventh Amendment context. And I think there'll be a lot of debate about public versus private rights. Again, I think this is a little bit of a labeling fight. The court has said public rights can be adjudicated by non-Article 3 tribunals. I think some patent owners are worried that if patents are put into the public right category, that may call into question takings and other kinds of protection. I don't think that's necessarily true, but I think that's part of the argumentation that you'll hear. In the big picture, big consequences for the patent system, depending on how this comes out. There's been a lot of concern about overbroad patents strangling competition. Obviously, if there's a patent and you have a new invention, that patent could be blocking your new invention from getting to market. And so if that patent is overbroad and was unlawfully granted, you'd like to have it taken out of the way. Otherwise, you're going to have to pay that patent owner some kind of a toll in order to get your invention to market. So big competition questions in the patent system, and more broadly for administrative adjudication as a whole, if this government-created interest can only be looked at and perhaps revised by an Article 3 tribunal. What does that mean for other government-granted interests? We can all think of licenses, benefits, payments, all kinds of things. Those things all have to be put into the Article 3 court system.
Thanks a lot. I know Sam wanted to follow up, but can we just hold that till the
Sure, of
end?
course.
Because
course.
we still have wedding cakes, cell phones, political redistricting, online, so and campaign, yes, so gambling, yeah. Let's remember, so we'll come back to that at the end, but I'm going to go to Orin now, who's going to talk about Carpenter.
Great. Thank you, Jan, and thank you to the Federal Society for the invitation. Carpenter versus United States is probably the biggest Fourth Amendment case that the court has had in at least 5 or 6 years, maybe longer. It is bringing together a bunch of important questions about how the Fourth Amendment applies to new technology, to the internet, to a world in which we're using new devices and the government's collecting new kinds of records. And the question is, what's the line between what is up to Congress and what is up to the courts? That is, what is something that we can have privacy legislation on, and what is something that the courts say this is covered by the Fourth Amendment, prohibition on unreasonable searches and seizures. The question in the case is about cell phones. In particular, whenever your cell phone is on, it's trying to communicate, and likely is communicating, with local cell towers, which it needs to deliver the call, or text messages, or anything to or from your phone. Your phones don't work by magic. They work by connecting to local towers that the cell phone companies own, and then they route your communications for you. It turns out that the cell phone providers keep records about which cell towers were connected to which phone accounts historically. So your phone company has a record of which towers you used to connect when your phone was on, or when calls came in, and when you sent calls. And those records can be very useful in government investigations to get a basic idea of where somebody was located. They're not particularly precise records. Usually they vary, but usually we're thinking sort of whether somebody's in a particular neighborhood, not whether they're on a particular block or in a building or in a room. So the information of knowing where a phone was in what neighborhood is not hugely important on its own, but can often be very useful when combined with other information to figure out, for example, a group of people went from one area to one area. In the Carpenter case, it was used by the government to show that Carpenter and his co-conspirators were in the area of a string of robberies. Each robbery would occur, and what do you know, all the phones used by the conspirators were always in that area, helped to show that Carpenter and his co-conspirators were the ones behind the robbery. The government collected records about the location of Carpenter's phone from 2 cell providers covering more than 100 days of coverage, so a lot of records obtained. And it did so under a federal statute called the Stored Communications Act. In particular, a provision enacted in 1994, which says that for the government to collect non-content records about an account, whether it's an internet account or a telephone account, the government needs a court order from a judge, and it needs to show specific and articulable facts that the information to be obtained is material to an ongoing investigation. This is, for those of you that follow Fourth Amendment law, the Terry versus Ohio standard of what the government needs to do to stop somebody and temporarily detain them. Congress enacted that same standard in 1994 for non-content records, and that includes cell site records. So the government got these court orders, used the location information. The question in the case is whether the Fourth Amendment effectively requires a higher standard, the probable cause standard, and whether obtaining the records about individuals' location from the cell site records collected by the providers is a Fourth Amendment search of the interests of the users that would require a probable cause warrant. 2 questions in the case. One, is it a search of that person, their interests, to get the records? And then second, if it is a search, is it a probable cause requirement search, or maybe there's some lower standard, like perhaps the statutory standard? So that's the issue in the case. It's hugely important because although this case is just about cell site records, really it's about much more. This is the first case that has touched on Fourth Amendment rights, what is a search in the context of new technologies in several years, and really the one that is getting to the fundamental basis of what is constitutional and what is not covered by the Constitution in the surveillance laws. The traditional rule that the Supreme Court has supplied is that the government does not conduct a Fourth Amendment search when it is obtaining records from a third-party business. So you can sort of imagine the world from the investigator standpoint. There are some investigative techniques that aren't covered by the Fourth Amendment, and other techniques that are covered by the Fourth Amendment. Government it doesn't conduct a search to use an undercover. Government does conduct a search to wiretap a phone line. Government doesn't conduct a search if it collects bank records from somebody, but does conduct a search if the government breaks into somebody's home. And so the world of criminal investigations is divided between things that are searches and things that are not searches, and that line is really what's at issue in the Carpenter case, not just for cell site records, but for internet records, for bank records, for credit card records, for telephone records of who called what at what time. This is really going to be about where do we draw the line between what is constitutionalized and what is not for broader surveillance powers, broader than cell site records. So it's a hugely important case. The government, in its brief, which was filed just 2 days ago on Monday, relies on the court's precedents effectively established that third-party business records are not, can be collected without a search occurring. They're the third party, somebody who's communicated with a third party, given their bank records to the bank, or called the phone company effectively to deliver their phone calls. The companies there have collected these third-party business records. It's not a search for the government to go to that effectively sort of eyewitness to the conduct and say, give us your records about what you saw. And so Smith versus Maryland and United States versus Miller cases from the 1970s, which are probably the best known example of these cases, would say that it's not a search for the government to collect the cell site records, and that was the reasoning of the Sixth Circuit and other courts of appeals below. On the other hand, Carpenter says we're in a new technological world here. We can't follow necessarily the old rule that was used in a different technological era, and Carpenter relies a lot on the concurring opinions in United States versus Jones. Jones was a case from a few years ago involving installation of a GPS device, a tracking device on a car, collected information about the whereabouts of the car, very precise information over a long period of time. I think it was 28 days. And the majority, in an opinion by Justice Scalia, says a search occurred when the government installed the device, but the concurring opinions, collectively including 5 current justices on the court, said that there should be a different rule, that it was over time the collection of the records were so precise and they collected so much information about somebody that at some point that became a Fourth Amendment search. The reasoning of Justice Alito's concurring opinion being that short-term surveillance is different from long-term surveillance. Nobody would expect long-term surveillance to occur, for the government to collect so much information, and therefore that begins to violate a reasonable expectation of privacy at some point. Carpenter says, well, this is just like Jones. This is a long-term collection of records. Government responds, this isn't like Jones at all because the records are so much less precise, and here we're dealing with third-party business records traditionally covered under the old rule that it's not a search. What I think makes this case fascinating beyond its importance for the internet and for the technological era, there's so many directions the court could go in and so little of what the justices have written themselves on these issues. So the court took this case without a split. There was no clear split from the courts of appeals suggesting they wanted to take a look at it, which of course that maybe suggests maybe they want to have a different rule because they didn't wait until there was disagreement. But I suspect, this is just my speculation, that they wanted to take a look at something which is hugely important to the structure of government investigations in a networked world, and on which none of them were on the court when the precedents that they're relying on had been decided. So we have cases from the 60s and 70s and early 80s. The current justices were not on the court at that time, and I think they want to take a look, and there are just a lot of different places they could go. Really tough to predict, I think, what the court might do. You can look at the concurring opinions from Jones, say maybe they'll go with that, but there are also reasons to think that that was kind of a one-off for that one kind of case and that this case is distinguishable. In particular, an interesting angle to watch, I think, is the role of legislation. So in the Jones concurring opinion, Justice Alito says, in the absence of legislation, it'd be great if we had legislation that covered the use of GPS devices. In the absence of legislation, we'll adopt this Fourth Amendment rule. And Justice Sotomayor, in her Jones concurring opinion, also suggests that in the absence of a coordinating branch doing anything, we need to cover this under the Fourth Amendment. Well, the cell site question is something that legislatures have been very active on. So Congress enacted the 1994 Terry versus Ohio standard that applies at the state and federal level. Congress has had a bunch of hearings, by my count 5 of them, on whether to raise the standard to probable cause over the years since then. Several states have enacted a warrant requirement for collection of cell site records that would only apply for state and local investigations. So we've got a lot of legislation, including quite recent legislation at the state level, and it'll be very important and interesting to watch whether the existence of legislation leads the justices to think about surveillance a little bit differently and makes it more kind of where does the court step in where the legislatures have acted versus the court sort of occupying the field. Traditionally in Fourth Amendment law, it's sort of the courts or nothing. If it's a question of whether the government needs a warrant to break into a house, that's going to be something that's a traditional Fourth Amendment function. And here we have the added angle of new technology and also legislation being active here, and the court's going to have to figure out what is up to legislatures and what is up to the courts, again introducing or reintroducing this separation of powers theme to the current term. So I'll leave it at that.
Do you want to mention the one that's working its way up, Microsoft? Do you want to just come back to that at the end?
Whichever you prefer.
Why don't we remember to come back to that? Sure. But I mean, I guess just going back to Carpenter then, I mean, so like sometimes we tend in the media at least, to, as you guys all know, exaggerate things sometimes. Like this is, the most significant, but I mean, this is really a case that is kind of, as you're saying, on the cutting edge of how the Fourth Amendment is going to kind of unfold in this new technology world we're in.
Yeah, this is the case that's going to...
You can't overstate the importance of this case, really.
Well, as somebody who writes in this, I think the entire world is basically resting on this. I have a lot of law review articles that are either going to be prescient or completely outdated based on what the court does. But yeah, this is really, this is the case that's going to determine limits on the government's surveillance power at the state and federal level in new technologies for years to come. And I think the justices know that. This is not a surprise to them or a secret. That I think they took this case in order to figure out, okay, what are the surveillance rules in this new technological era that we're in? And it's funny, if you look at the briefs in Carpenter itself, you think, well, wait a minute, why does this matter? So already there's a specific and articulable facts statute, so that's one threshold, and a bunch of states have gone to probable cause. The stakes for cell site data are actually much less significant, I think, than for all the other information. So this is a case about cell site records technically, but really it's about internet surveillance. It's about network surveillance in a world that the justices are certainly aware of, moving towards online communications and spending a lot of time on the internet, and as many of us, certainly I do, this is the case that's going to set the ground rules for that. So, certainly the FBI cares a lot about what's going to happen, and the NSA cares a lot about what's happening, and this is going to be really the big surveillance case for the internet. Happens to arise this term in the context of cell site records.
All right, great, thanks a lot. All right, so we're going to go to Kyle now to talk about wedding cakes and maybe a little bit about betting.
Yeah, I get to talk about cakes and gambling and Governor Chris Christie, so I get to talk about the really interesting cases.
And Christie is not involved in the cakes case.
Not the cakes.
Okay.
No, that's the gambling case.
Sorry, I couldn't resist.
That's all right. The Masterpiece Cake Shop versus Phillips. Versus Colorado Civil Rights Commission is, as Orin was saying, if that's a blockbuster Fourth Amendment case, this is a blockbuster First Amendment case. Because it poses, for the first time, and of course not long after the Obergefell decision, about the conflict between the rights of same-sex couples to marry and also to be free of discrimination in public accommodations, put over against the rights of a religious entrepreneur not to participate in a ceremony that violates his own religious beliefs, and also not to engage in speech or expressive activity that he doesn't wish to engage in. So this case has gotten a lot of attention already. It was relisted, I tried to count, something like 14 times, which is, SCOTUS blog can tell me if that's a record or not, but 14 times. It was finally granted almost a year after it was first filed. What are the facts? Petitioner is a Christian cake designer or cake artist. If you watch as much HGTV as we do in my home, you know that there are shows about cake artists. Ace of Cakes, I think, is a particularly good one. He declined to design a custom wedding cake for the respondents, who are a same-sex couple. They wanted the cake for their upcoming wedding. When they filed a complaint against Mr. Phillips, is his name, Jack Phillips, he was found to have violated the Colorado Anti-Discrimination Act for engaging in sexual orientation discrimination. And he was ordered to engage in various remedial measures, such as re-educating his staff, providing cakes on an equal basis for gay and straight weddings, and other measures like that. The Colorado courts rejected his argument that this application of the anti-discrimination law violated his rights under the Free Speech Clause and the Free Exercise Clause of the First Amendment. There's so much one could say about this case. Let me just, and the briefs have come in on one side, but not on the other, so I'm at a little bit of a disadvantage. The petitioner and his amici have filed tons of amicus briefs, as you might expect. Let me just sketch out what I imagine the free speech claims are going to be on both sides, not just one. The free speech claim is going to come down to some very basic and interesting questions that free speech law doesn't quite totally settle, as you might expect, such as when a cake artist, or some sort of artist that's not a traditional artist that we think about, is he engaging in First Amendment protected expression by designing a wedding cake? And if not, is this the kind of expressive conduct that we might see in cases like O'Brien versus United States, which is the burning the draft card, where somebody engages in conduct that has an expressive component? If it's expression under either one of those categories, is application of the anti-discrimination law compelling speech in violation of the First Amendment? So the briefs on the petitioner's side are talking about a lot of very familiar, but as Orin was saying, very old cases that don't address anything like this scenario. Instead, you'll end up talking about cases like Barnett, West Virginia versus Barnett, which is the pledge case involving Jehovah's Witness student who didn't want to be forced to say the pledge and who won, of course, in that famous decision from, I think, from the 40s. Needless to say, the petitioners are trying to construct their case so that it's the next Barnett case. And then there's a number of other First Amendment compelled speech cases, such as Hurley, the Irish parade, gay parade marching case, Woolley versus Maynard, the Live Free or Die case. I've just spent a long time in Maine, and we saw a lot of cars from New Hampshire. I point out to my children every time a Live Free or Die car would go by that, look, that's an important constitutional principle there, and they were not interested at all. On the respondent's side, and I'm judging this from the way that the Colorado courts dealt with the issue, and although they might develop all sorts of new arguments as well, I would imagine the respondents are going to stake their ground on one point. For example, the activity of making cakes isn't speech. It's not expressive conduct at all. It's not inherently expressive, and so the case is far less like a case like Barnett or Hurley, and more like Rumsfeld versus Schaerr, which is a very recent case involving law schools who objected on expressive association grounds to hosting military recruiters during the time of Don't Ask, Don't Tell. And they lost that case because, oversimplifying, the court said that's not inherently expressive activity to host military recruiters. They might also ask, I imagine their briefs are going to ask, well, if it is speech, whose speech is it? Isn't it the couple's speech who's getting married and not the baker's speech? These are very interesting claims. You got a ton of amicus briefs on their side. I have to say the most interesting brief is filed on behalf of neither party, but it's filed on behalf of cake artists. And it's full of beautiful full-color pictures of cakes that are astonishing. My favorite, and I hope this doesn't reveal too much about me, is a cake where a cowboy is riding on a pig. And it's just an astonishing cake. I have no idea why somebody would want a cake like that. It's probably very private, but it's a very, very interesting cake. And I think the point of the brief, as it said, is not to support either party, but to show that there is, in fact, expressive activity in making cakes. Very quickly, there's also a free exercise claim, just to raise the stakes of this case even higher. The free exercise claim is that by compelling the petitioner to engage in what he considers a religious event, a wedding that goes against his beliefs, by compelling him to participate in a meaningful way in that, it's forcing him, it's violating his free exercise of religion, as opposed to abstain from doing that. And the technical legal issue under that claim is extraordinarily important. I don't know if the court will reach it or not. But it's how the Smith decision, the infamous Smith decision from 1990, applies. Smith says that a law that is neutral and of general applicability essentially can't burden free exercise rights. That's oversimplifying, but that's what Smith seemed to say. It's very controversial. Justice Scalia wrote the opinion. And so the question is the Colorado anti-discrimination law here a neutral law of general applicability? Or is it being applied by Colorado in a way that is not? And the petitioners, and I don't know what the respondents are going to say back to this. I'm sure they have an answer. But the petitioners are saying, look, there are cases from the Colorado Civil Rights Commission that have recently allowed cake artists to refuse to put anti-homosexual or anti-gay rights messages on cakes. And so they're not playing fair. They're playing favorites by requiring the petitioner in this case to have a pro same-sex marriage message on his cake. But that raises a very interesting issue about whether the record actually discloses what he was asked to do on the cake. I don't know that it is. I was reading some commentary on the internet that suggests that, well, there's nothing in the record that says he was required to put a pro same-sex marriage message on the cake. And so that raises all sorts of interesting questions. The case will be a blockbuster. About 20 states have come in on the side of the petitioner, and we'll see, no doubt, states and all sorts of amici on the other side. I'll be quick about this as I transfer over to Governor Christie and gambling. Christie versus every sports league you ever heard of, NCAA, NBA, NFL, NHL, Major League Baseball, are involved in a titanic dispute over federalism. This is an anti-commandeering case, which, as you acolytes of federalism know, is a very important 10th Amendment doctrine that says the federal government can essentially tell the states how to legislate or tell state executive officers to administer a federal program. Those are cases of New York versus United States and Prince versus United States. The court hasn't had an occasion to revisit this doctrine, but now it does in this very interesting, and I have to say, as I got more into this case, difficult to understand both procedural and substantively. What's the federal law at issue? Let me try to simplify it. The Professional and Amateur Sports Protection Act, or PASPA, is a 1990 law that prohibits states from doing a bunch of stuff, I paraphrase, with respect to sports wagering. One of the things that it prevents states from doing is from authorizing sports gambling by law, which I think will turn out to be the key statutory phrase in this case. New Jersey initially had an exemption from PASPA if it wanted to regulate sports wagering in its state within a year of the passage of the law, but it didn't take advantage of it. But then in 2010, evidently it had second thoughts and decided to enact a regulatory scheme to regulate sports wagering, which of course violated PASPA. It was sued by all the sports leagues in a case called Christie 1, and it lost in the Third Circuit. And specifically, it lost on the issue, the argument that it was making that PASPA commandeers states. And when I first read that, I thought, well, how does PASPA commandeer states? It just says don't do that, right? That doesn't sound like commandeering. But as I got more into it, it got a little bit more complicated, because the way that the Third Circuit seems to interpret PASPA is to say, if you repeal existing prohibitions on sports wagering, which of course don't apply just to the state, but apply to private parties, then you've authorized sports wagering by law, by repealing your state law, which, if that's true, if that's how PASPA works, and of course the sports leagues will say that it doesn't work that way, but if that's true, then the federal law is telling states to keep sports wagering prohibitions on the books if they have them, which does begin to sound a little bit like puppeteering the state legislative processes. Very, very interesting case. En banc Third Circuit said no commandeering. Really interesting opinion by Judge Rendell for the majority, 9 or 10 judges. Really interesting opinion from Judge, I'll get this wrong, Vanaski. I almost said Zabriskie, but that's different. Vanaski saying, no, this is commandeering. Very, very interesting. Big lawyers on both sides. Ted Olson arguing for New Jersey. Paul Clementa, I assume, will be arguing for the sports leagues. A huge federalism case. I must say just one point, and then I'll stop. The first time around, I thought this was fascinating. The first time around in the Third Circuit, the New Jersey lost and they sought cert. And the United States Solicitor General at the time, I think it was 2014, told the Supreme Court, well, look, there's nothing to worry about here, because PASPA still allows New Jersey to repeal its sports wagering prohibitions in whole or in part. Nothing to worry about here. I'm paraphrasing, of course, but that's what they said. And then so it went back. New Jersey did that. From New Jersey's perspective, they were just doing what they were told they could do. And now, this time around, they find that repealing it means authorizing it by law. And so this is a big part of their argument. It will remain to be seen how the court deals with this. Very, very interesting and important case. 18 states and the governors of 3 other states have weighed in favor of New Jersey, also a bunch of associations like the National Government Association and the National Conference of State Legislatures. Okay, sorry for the speed talking, but I wanted to get through all that.
Thanks so much. And finally, we're going to go to Carrie Severino to talk about the redistricting case, and Gil.
Right.
And then after that, I think we'll open it up some questions from the audience.
Great. So anyone who follows the Supreme Court redistricting cases knows that what we're going to see here is basically follows a very typical pattern, which is a case comes up with sort of a messy history of facts, trying to interpret an even messier set of principles that have been derived from the Constitution and elsewhere by judges, and then at the end of the day, they come up with a decision that changes or doesn't the actual contours of these districts and provides little to no guidance going forward for the future cases. So the backdrop that the case is coming from is, I guess, 2 major cases, neither of which had a clear majority. So this is what we're working with here. Davis versus Vandiver in 1986 and Veith versus Jubiler in 2004. And the big question is partisan gerrymandering something that the courts can even address? So it's something that I think a lot of us feel uncomfortable with. I think a lot of the justices aren't happy about and may even have questions of whether it should be inherently lawful at all. But it really, in many ways, that line of cases boils down to, is this something that courts can even look at? And there's a lot of disagreement. Both of those cases came up with plurality sorts of decisions. So in the 1986 case, they said, well, yeah, we think you can come up with a judicial standard, and here's the standard we think kind of works. Is there partisan intent? Is there partisan effect? And then when the court reconsidered it in 2004, they said, look, we've been using this test for 18 years. It's proven to be virtually impossible to apply. So when they thought they were coming up with a discernible standard, and then one that was manageable, it really wasn't. And there you had 4 justices who said, this is just a political question, doctor, and that, saying this is something that the court can't even look into because there's nowhere we can get a standard to apply here. And then 4 justices who said, no, we can look at partisan gerrymandering claims. And then Justice Kennedy concurred in that case, basically saying, well, I'm not willing to say you can't prove a negative. I'm not willing to say there's no judicially discernible standard until you could prove that there is no standard, which is, of course, logically impossible. So I'll just say, and this is sort of fits with Justice Kennedy's general penchant toward not actually, not completely coming down with a clear answer in everything he can. So he basically said, I'm leaving the door open, and this standard is not a use. There's no standard that they came up with in this case that satisfies me. But who knows? Eventually, someone might come up with a standard. So cue 13 more years of litigation trying to guess what guess what would Justice Kennedy do? What standard might be something that would appeal to him? And I suspect that that's going to be what we see in the case today. Now, it's significant that in that concurrence he did acknowledge that some levels of political gerrymandering actually is acceptable. That just the mere fact that you can point to, hey, politics were a factor in this, doesn't mean it's overturned, which is a good thing, because frankly that would probably mean that every single redistricting effort that has ever happened in this country would be unconstitutional, because I can't imagine that there's ever been a case where politics has been wholly absent, or maybe even predominantly absent. There's lots of evidence that political gerrymandering has been happening for the entire history of the nation. Even if it has been criticized for the entire history of the nation. So the specific facts of this case, this has to do with Wisconsin redistricting, and basically their current redistricting has been challenged by a group of 11 different plaintiffs. There's not one from every single one of the 99 districts. That becomes a problem as well. And the court below, it was a three-judge court, as happens in these cases, overturned their current system and mandated that they redraw the lines in the meantime. Significantly, the court stayed that order. So when they accepted this case, they actually stayed simultaneously the order to redraw the district lines. The state was arguing we shouldn't need to do this. Why not just wait for the Supreme Court to tell us whether they're okay or not? It's going to be a huge amount of time, effort, state in attacks on state resources to do so. And that's very interesting. First of all, it's interesting because 4 justices did not want to stay that order. So I think it's safe to say that those are the typical 4 liberal justices. I think it's safe to say they likely lean toward the fact that there's a real potential for these districts to be overturned on the political gerrymandering basis. And then 5 justices obviously must have voted to stay, and that we know which 5 they were because they didn't dissent from the stay. So the other 5 justices, and of course said that this order of the lower court was going to be stayed. That suggests that they also may have a thumb on the scale in terms of thinking that there's a likelihood of success in the merits in this case. So the real questions being considered here are, first of all, a serious question of standing. As I mentioned, you have people from a subset of the districts. 1/9 of the districts are represented in the case, but they're challenging statewide the redistricting. And this does raise an issue of do they have standing to do so? Do they have a particularized injury as to something that happened in another state? There's, for example, one plaintiff was in a predominantly Democratic district that was won by the Democrats. So, where's the harm under both pre and post this new redistricting? And the appellants, in this case it's appellants, not petitioners, point out that this could be a problem because in racial redistricting cases, typically you have to be from the actual district you are challenging. You can't just challenge statewide. Racial redistricting, they said, it would be a very perverse result if it's harder to get into court to challenge racial gerrymandering than it is to challenge partisan gerrymandering. In a world where we all, we have a specific constitutional amendment addressing the right to vote, and it's very clear that the Equal Protection Clause is supposed to address that as well. And yet, historically, political gerrymandering has almost been a safe harbor and a escape from racial gerrymandering claims. Traditionally, when the states come in and they say, you're racially gerrymandering, they say, oh no, it's just politics. And we had one of those last term. No, it's okay, this is just politics. Oh, okay, good, you can do political gerrymandering. It would be very strange to say that it's actually easier to make those political gerrymandering claims, which have traditionally been kind of let go, when you wouldn't be able to challenge a law for racial gerrymandering. I think then they have 5 questions presented. It's an amazing number, which also differ from the appellees' 4 questions presented. So I think the court goes with the appellants. It seems they didn't edit those. And then second, they ask if there's a safe harbor under the Veith case. That was the 2004 case for traditional redistricting principles. So if you were using these traditional principles, you have a safe harbor, because they point to all of these traditional principles they had looked at, so the court will look at that. And then they criticize, in the third question presented, they say, are we just going back to the Davis versus Bandermer standard? So the standard proposed in this case is very similar in some ways to that standard of the plurality in Davis that seems to have been updated in the 2004 case and not adopted by them, or certainly at least 4 members of the court said it wasn't workable, and Justice Kennedy suggested it wasn't workable, and that was the combination of intent and effect, discriminatory intent and discriminatory effect in the law. The appellees in this case propose a third prong as well on their test, and they specify that it has to be a significant discriminatory effect, and they use particular social science, they have a particular social science standard they have developed, the efficiency test, although the court didn't even apply that. They applied yet another slightly different test. So there's a million tests already in the room. And then they also add the third one, which is that they don't have you can't kind of justify it. Maybe it's sort of a burden shifting thing of, well, if you can shift then the burden back and say there's a neutral reason we had this discriminatory or apparently partisan discriminatory effect, then we can get out of this. So that question seems to ask, is this just the same disfavored test that was used in a previous one? And then the last two, or the fourth one has to do with whether the trial went well. So effectively, the court come up with this new standard midway through, and they didn't have the opportunity to introduce proper evidence because the court did kind of invent a new standard after it had already been. That three-part test had already been proposed by the appellees, the plaintiffs in that case, and then finally whether these claims are even justiciable at all. So I think I think is going to be it's an uphill battle for the appellants, just insofar as Justice Kennedy has already asserted that you cannot prove a negative. I doubt that in the intervening 13 years he has been convinced that now it really is clear there's no judicially discernible standards, but whether he'll find this one any more compelling than he found the last one is also a question, a tough question for me. So I'm not sure how if they'll be able to distinguish the test. I think that's what's going to be going on in the oral arguments. You'll have the appellants saying, look, this is just like Veith, this is no more useful a test, and frankly, you should throw us all out on standing in the first place. And then you'll have the appellees saying, no, in the intervening time, we've seen the amount of partisan gerrymandering increase. We've seen new technologies which make it easier and more effective to do partisan gerrymandering, because we can pick and choose who lives exactly where with these great computer programs and data collection things we have. And plus we have this shiny new social science test that you can apply. Whether that's compelling, I don't think it'll be compelling to the 4 members of the court who already think this is not politically justiciable, or this is not justiciable because it's a political question. But I do think it's possible that we might see Justice Kennedy swayed one way or the other. Even more likely, though, just based on the pattern we see in these cases, that there's not going to end up with a very clear test by the end of the day, however this ends up working out. I wanted to just comment, since I know we're at the end here, about, because I think some of the we have so many interesting cases today, but some of the most interesting ones almost are that form some themes in this term haven't even been granted yet. So just to flag a couple of them. First, we had, Kyle mentioned the Masterpiece Cake Shop compelled speech case, or at least one aspect of it is compelled speech. And I wanted to flag a case from the 7th Circuit, the Janus case, which is also a compelled speech, that in the context of public sector unions. Many will remember from a couple terms ago, the Friedrichs versus California Teachers Association case that was heard just before Justice Scalia's death. I think everyone thought that it was a clear 5-vote victory for not being able to force public sector employees to pay not technically dues, but effectively a very similar amount to a union that they didn't want to be a member of. So it was a compelled speech in that case. It seemed like it was going to overturn the precedent that allowed that to take place, that compelled speech to take place, and then Justice Scalia died. I think this could be the kind of reboot of that case, and if so, I would suspect that Justice Gorsuch would also be very critical of the Abood line of cases, which is what was at issue there, and that could also be a very interesting case. And then the second set is kind of fits along with the Oil States case that Andrew's talking about. they have to do with these major structural constitutional issues. There's two cases coming out of the DC Circuit, the CFPB, one challenging the constitutionality of the CFPB, that the CFPB lost and then was reheard en banc, and then also one challenging the constitutionality of administrative law judges called Lucia. In that case, the petitioner or the plaintiff lost and the SEC won, but also I think, I can't remember if that one's gone on bank or is going on bank at the DC Circuit. And I think those are both very significant. They make similar types of arguments of here is in the case of the CFPB, here's an agency that is not constitutionally organized. You have someone who they have no check on the head of this agency, either from the Congress or from the president with removal powers, et cetera, and how can this exist in our constitutional system? And similarly, the challenge to the administrative law judges. And it kind of fits a little bit with what's going on in the oil states case, where you have really a parallel quasi-judicial system going on there. I'll point out that I do think in terms of the oil states case that I agree it's going to turn on the question really of whether patents are property, but I think when you look at the history, there's actually some really strong historical evidence all the way from our 18th century cases in American law to common law cases in Europe. I mean, the Seventh Amendment talks about cases at common law and that patent cases in England had been dealt with at common law. So it seems like it fits very squarely into the concept of here's a property right. And when you pair that with some of the real serious due process issues that are going on there, I mean, obviously there's the question of are these people appointed properly under Article 1 or Article 3, but I think when you look at the Patent Trial and Appeal Board and the due process questions they've had, whether it's stacking panels or just the standards of proof are very different than that you would have in an Article 3 court, et cetera, and they seem to, with a over 2/3, I think, patent invalidation rate, and they seem to have a sort of an agenda that doesn't seem terribly well masked, or maybe I'm not sure they're even intending to. I think they sort of view it as their agenda to try to get rid of as many patents as they can, and that's something the Chief Judge has embraced to a certain extent. I think that's exactly what our constitutional system was designed to protect against by having all these due process guarantees that we have, and so I think that'll be really interesting when if the court is, if they think they ought to recognize that if this is actually a property right, to have a roving, it's been called a death squad for patents going out there without any due process protections is really very problematic constitutionally, and so all three of those cases will form an interesting, way for the court to review what those constitutional structural protections are there to protect. So.
Thanks so much, Carrie, and I just want to say thank you to all our panelists. I mean, I've got I very much appreciate the context and insight in what's going to be a really, I think, exciting term, and then obviously cases on the horizon as well. I thought we'd take a few questions briefly, if there's anything that you guys would like to kind of flag, or if our panelists would like to, well, people might want to come to the microphone, anything that you would like to weigh in on while we're waiting.
Well, while we're waiting, I'll just say a word about Carpenter. I just want to echo what Orin said about how, in a way, the focus on the cell phone location data is really the least relevant kind of third-party information. If you think of your own information and, the emails, documents, photographs you have stored in the cloud, right? Those are all in the hands of a third party. All of the information, if you've got a Fitbit, all the information that device collects is stored in some Fitbit computer somewhere, so multiply by that by every kind of device that you use. There's a huge, huge amount of data that is now in the hands of third parties that just, let alone in the 1780s, even in the 1980s, didn't exist. And what the court decides about the parameters for government access to that is just going to be critical for privacy protection for the next number of years.
Just a word about the arbitration cases. The Consumer Financial Protection Board also has a rule banning class action arbitration. The CFPB, of course, its constitutional status, as was pointed out, is up in the air because it's the single-member agency, not a multi-member agency. And it's not supervised by the president, and on top of that, it doesn't have to worry about congressional appropriations because it gets its money from the Federal Reserve, so it really is a power unto itself. That's another case. I think there's an overlap or connection between Chevron issues and the survival of these class action, no class action provisions. Because I think in both cases, certainly in the NLRA case, there is a question whether the board has this authority to begin to regulate non-union systems. It has the authority to protect people as they seek access to whatever fora are available out there if they involve workplace issues, but the board does not have the authority to regulate those fora. So it's not just an Federal Arbitration Act question, it's a statutory authority question, and it raises the issue of Chevron, especially in a context where the agency is reaching out beyond its usual sphere of responsibility.
I want to, if no one has any questions for them at the mics, I want to kind of ask us to kind of go to about 10,000 feet and just look broadly at what we see as themes that might be emerging from this term, or, you know, if you want to talk about Justice Gorsuch, I mean, obviously it looks like he's developing some relatively predictable voting patterns, though justices certainly can change. But if you could just kind of step back and just give us some of your broader thoughts on whether a justice, a theme, potential retirements. You want to start with you, Kat?
Sure. One thing that occurred to me as I was listening to the comments was we've got a new administration, obviously. We've got a new Solicitor General. We've got a new Justice Department. We've got a new Attorney General. As SG was just confirmed. I'd be curious to see what effect on the court may happen from the change in position from one administration to the other on important legal issues. I forgot to mention that in the Masterpiece K case, the Justice Department has filed a brief on behalf of the petitioner. In that case, and I don't know if formally that's a change of position, I just don't know, but it has raised eyebrows that the U.S. SG's office came in on the side of the petitioner. I may be mistaken, Annie, forgive me if I am. I thought you said that the DOJ might have changed position in some way in the arbration cases.
In total, absolutely. Petition for
good,
the
I just didn't want to overstate it. Good. So totally. I mentioned that in the Christie case, the SG had seemed to take a position that was sort of pro-New Jersey being able to repeal its laws back in 2014. I don't know what their position is going to be in this new case. That's curious and interesting dynamic on the court to watch.
All right, we have a question.
Thank you. And Carrie, thanks for the plug for the Janus case. My colleague's litigating that. My question would be in regard to the new Solicitor General, as I'm sure most of the people on the panel, maybe in this room, know, Noel Francisco litigated the Noel Canning case, which Judge Santel's decision in the D.C. Circuit was a model of originalist thinking. Does anyone foresee a greater focus on originalism from the SG's office now that he's in charge of that shop?
Well, I certainly would view that as a wonderful step forward. I think there's a lot of cases that we've talked about already where that factor could play in, whether it's, you know, some of the original understanding of whether patents are property or what searches and seizures are and how we play that into today. I mean, there's all of these cases, I think, could benefit from some analysis on that front, what the original understanding of whether, you know, partisan gerrymandering is or isn't something the courts can even look at. I think that there's a lot of them that have that factor in them, so certainly might.
If you have a good original understanding argument, use it. That's my motto.
You're not going to lose your votes.
We were going to wrap up at 2. We got started just a few minutes late, so if it's okay with people in the audience, we could have another question and then maybe have our panelists just kind of say some concluding remarks.
Supreme Court Yearbook. At one of these sessions, one other expert suggested that Justice Thomas's joining the court pushed Justice O'Connor toward the left. And I wonder whether, and his implicit suggestion was Justice Gorsuch's joining the court might push Justice Kennedy to the left. I wonder what any of you have to say about that possible prediction.
Don't you mean to the right? What do you mean to the?
I think to the left. No, to the left.
No, he said
Gorsuch, oh, I see, as a reaction to his former clerk.
A backlash.
Yeah.
Gotcha.
I think one point I've made along those lines is I think it is different when so Justice Thomas replaced Justice Marshall, which is definitely a shift in approach on the court, right? Justice Gorsuch replacing Justice Scalia, to the extent that Justice Kennedy, I assume, would be the likely one, in addition to the fact that he obviously knows Justice Gorsuch better, and so maybe he's less likely to react negatively to him. It seems like there's no need to shift in order to maintain the balance. The balance of the court is actually pretty much exactly where it was 2 years ago, right? So I don't know whether that will play into it or whether there's more interpersonal things, but if you're worried as a justice, do I need to balance a shift? There's no shift. I
mean, I think even before Justice Scalia passed away, you could look at the court as the conservative side of the court as having sort of two distinct groups, right? 3 and 2. And I think that distinction is probably becoming even more pronounced if you just look at the recent decisions, even yesterday's stay in a death penalty case. So it seems to me one way of looking at the court is you have a sort of a 3-justice group, Justices Thomas, Alito, and Gorsuch. You have the Chief Justice and Justice Kennedy, maybe more toward the middle. On the left, you probably have Justice Breyer and Justice Kagan, a little bit toward the center, and you probably have on some, obviously this is an oversimplification, Justice Ginsburg and Justice Sotomayor in a different place. So I think, the sort of paradigm is, it's, 4-1-4 and Justice Kennedy is in the middle. That's sometimes true, but I think it's actually the breakdown is a little more complicated.
I think the more significant change is Justice Scalia is not there anymore, because I think he had an enormous impact on how the cases were argued and reasoned by the justices. So the very strong emphasis on textualism that he imparted, I think, is not there in the same way. I don't think Justice Gorsuch at this point is going to play that role.
All right, my question goes to the Masterpiece case, and whether, given that we are now in a post-Obergefell situation, what are the implications for this litigation in terms of balancing different interests that are at stake?
I think it's extremely important. I think you were seeing these kinds of to coin a phrase, wedding vendor, wedding participation kind of cases arising, popping up. There was the Elaine photography case out of New Mexico, I think. That presented some of the similar issues to this one. The court turned it down. You had the Stormans case out of the Ninth Circuit, which didn't have to do with same-sex rights, but it had to do with sort of forced participation against someone's religious conscience and behavior they didn't want to participate in. In that case, it was distributing Plan B, I think. That was turned down by the court over a very strong dissent by Justice Alito. And now the court's wading in. And I think the way you put it is right. I think the court as a whole will be struggling to find the proper balance. They won't be able to make everyone happy, of course. Not in these cases, you never do. But the sort of balance that they decide to strike in this case, it won't determine every case after it, but it will set a template, I think, for how these issues are to be worked out. It's very important.
Well, again, I'd like to thank everyone here for this enlightening conversation, and thanks to the Federalist Society and Lee for bringing the panel together and for giving me the opportunity to moderate it. Wish I said it, just wish we had another few hours to go on. I'm going to just ask if there are any final thoughts, any points that you guys want to make, and then sadly, I think we're going to have to wrap it up. Orin, you want to? I know you were quiet about Justice Kennedy. I remember he clerked. Is he going to retire this year?
Yeah, I have no inside information. So I think a really interesting dynamic to watch this term is going to be the reaction of the justices beyond Justice Kennedy, although including Justice Kennedy, to the current occupant of the White House. There's been writing in the popular press and on blogs and the like about some Trump effect of sort of justices or judges thinking, wait a minute, we've got a different situation here in the White House, and we should be modifying how we approach certain issues in response. And I wouldn't be surprised if we see a couple of big cases this term that reflect some sort of Trump effect at some level. Whether that should happen or not, of course, is separate, but I wouldn't be surprised if we do.
Anyone in particular you're going to be watching? I mean, obviously, you could make the argument that the lower courts and the travel pause cases certainly were doing that.
That's, I think, the easiest one to watch, but we may see it in other cases, too.
And that effect overlaps with a general concern among a number of the justices about the administrative state and Chevron and the separation of powers issues that we've been talking about. And so I think it is just another factor at play in all of these cases that will involve deference to agencies, structure of agencies, responsiveness of agencies to the political process. All of that is sort of a piece.
A concern I have is the Trump effect, is it's, people are going to forget, I think, about the institutional values that need to survive the presidency. And, the willingness to entertain this impeachment evidence, for example, in the Travelgate case, and we're seeing it in other cases, the Sanctuary Cities case. We've got to think about the issue of what effect it will have on the institution of the presidency going forward.
Do you think that's the reason that the court kind of handled the travel ban case the way they did? Because they didn't want to reach a decision in that case?
I think it played a role.
Yeah.
I think it played a role.
All right. Well, thank you guys again so much.
Thank you.
That was fantastic. That was really That was great. I know. Right. No, I didn't do anything. It was fantastic. It was one of the best cases. I mean, the cases were great, but you guys were all just fantastic. Your comments. I'd love to stand. Yeah, I don't have a card. I guess I should. Do you? I'll show you mine.